Hi everyone, and welcome back to the official channel of LegalEdge. Now, I hope I'm perfectly audible and visible, right? So let's start with our session. And what we are going to discuss today is about the recent order of the Madhya Pradesh High Court, wherein they quashed the anticipatory bail which was given to the mother-in-law in this entire Twisha Sharma case or the Twisha Sharma incident. Okay. Up, what is important for us at this point of time to understand is कि what are the different types of bail, what exactly is a bail होती क्या है, कितनी types of bail होती है, what is the difference between bailable and non-bailable offenses. This is something which is important, which we must understand for the perspective of or from the perspective of our paper. Okay. So the basic thing which happened over here was that initially Giribala Singh, the retired district judge from the state of the Madhya Pradesh, she was awarded an anticipatory bail by the lower court or by the additional sessions court only. But subsequently, this anticipatory bail was being challenged by the family of the victim as well as the state in the state of or in the High Court of Madhya Pradesh. And finally, now Jabalpur High Court yesterday quashed the anticipatory bail or this protection from the arrest which was given to Giribala Singh. And the primary thing which Justice Dev Narayan Mishra stated over here was Justice Dev Narayan Mishra ruled that the lower court blatantly overlooked crucial material in the case diary. Case diary is basically the investigation diary of an agency. कोई भी पुलिस या इन्वेस्टिगेशन एजेंसी जब इनिशियल फेज में इन्वेस्टिगेशन कर रही होती है ना तो वो अपनी डायरी मेंटेन करके चलती है, उसमें सारी चीजें वो लिखते हुए चलते हैं. ठीक है. जस्टिस देव नारायण मिश्रा का यहाँ पर कहना ये है that the lower court actually blatantly overlooked the particulars which are mentioned in the case diary, missing witness statements, digital footprints, and damning medical reports. And on the basis of this, the Madhya Pradesh High Court cancelled the anticipatory bail which was granted to retired district judge Giribala Singh. अब इस entire issue की अगर हम बात करें तो wherein the deceased was Twisha Sharma, a 33-year-old woman who was former Miss Pune, an actor, MBA graduate, originally from Noida. And she was found hanging on 12th of May in Bagh Mughaliya, Bhopal, barely 5 months after her marriage. मैरिज के 5 महीने बाद ही उनकी डेथ हो जाती है और यहाँ पर उनकी डेड बॉडी जो है वो घर में मिलती है. एंड जो प्राइमरी अक्यूज्ड थे आपके इस केसेस में, the accused included Giribala Singh and Samarth Singh, the mother-in-law who is a retired judicial officer, district judge from Bhopal, and husband who was a lawyer. अब इनिशियली जब पोस्टमार्टम किया गया तो जो टाइमलाइन हमें देखने के लिए मिलती है इस एंटायर केस में, दिसंबर में लास्ट ईयर द मैरिज टेक्स प्लेस बिटवीन समर्थ एंड लेट त्रिशा शर्मा. ठीक है. फिर मई के पहले देयर वाज एन एलिगेशन रिगार्डिंग अ डिस्प्यूटेड प्रेगनेंसी एंड अ डिस्प्यूटेड टर्मिनेशन ऑफ द प्रेगनेंसी और अबॉर्शन एज वेल. 12th May को finally Trisha Sharma was found hanging in her matrimonial home. ठीक है. Then on May 13th, police seized critical physical and digital evidences. Then on May 15th, the trial court grants anticipatory bail to the accused. And then on May 18th, the accused holds a press conference maligning the victim, that infamous press conference which was conducted by Giribala Singh. And then on May 28th, the High Court cancelled the bail order. तो ये अभी तक पूरी टाइमलाइन यहाँ पर फॉलो हुई है जहां पर सीबीआई इज कंडक्टिंग द इन्वेस्टिगेशन एज वेल. जो फॉरेंसिक डॉसियर हमें देखने के लिए मिलता है, जो इनिशियल पोस्टमार्टम कंडक्ट हुआ, इस पोस्टमार्टम के ऊपर भी क्वेश्चन रेज किए गए सब्सिक्वेंटली because of the influential nature of the family as well, that the postmortem was not properly conducted, and therefore subsequently another postmortem was conducted by the team from AIIMS Delhi. अब इनिशियल उस पोस्टमार्टम में जो प्राइमरी कॉज ऑफ डेथ बताया गया, that was antemortem hanging by ligature, but the postmortem revealed 6 other antemortem injuries sustained prior to death. कि डेथ के पहले भी वहां पर कुछ इंजरीज इन्फ्लिक्ट की गई थी ऑन द विक्टिम्स बॉडी, which included 4 injuries on the left arm, 1 on the ring finger, and 1 on the head. And therefore, the medical query report officially ruled out the defense's claim that these injuries were caused by bringing the body down or transporting it to the hospital. ये जो एडिशनल इंजरीज वहां पर थी ना, दैट इज ऑन द हेड एंड हैंड एंड दिस रिंग फिंगर, अक्यूज की फैमिली का कहना ये था कि दीज इंजरीज वर इन्फ्लिक्टेड ऑन द बॉडी व्हेन दे वर ब्रिंगिंग द बॉडी डाउन, ठीक है, फ्रॉम द स्पॉट फ्रॉम वेयर द बॉडी वाज हैंगिंग, एंड ऑल्सो व्हाइल द बॉडी वाज बीइंग ट्रांसपोर्टेड टू द और टेकन टू द हॉस्पिटल। बट बेसिक मेडिकल क्वेरी में इन सारे एलिगेशंस को रिबट किया गया कि इस तरीके की इंजरी वहां पर कॉज नहीं हो सकती, and this was one of the major reasons that why the district court should not have awarded anticipatory bail to the accused in this situation. But वहां पर डिस्ट्रिक्ट कोर्ट ने या लोअर कोर्ट ने, perhaps because of the influence of the family or some other reasons as well, the court granted anticipatory bail to the accused गिरबाला सिंह। फिर जब डाउरी रिलेटेड हरासमेंट के क्वेश्चंस उठने शुरू हुए तो अक्यूज की फैमिली का कहना यह था दैट देयर वर मल्टीपल मनी ट्रांसफर्स व्हिच हैव डन टू द विक्टिम, ठीक है, और ये चीज डेथ के काफी महीने पहले की गई थी कि कुछ सर्टेन अमाउंट ऑफ पैसा विक्टिम को ट्रांसफर किया गया था फ्रॉम द अक्यूज फैमिली, एंड दैट इज व्हाट द डिफेंस वाज क्लेमिंग, दैट the financial transfers made by the accused to Twisha, interpreting them as a proof that no dowry demand existed, क्योंकि हम ही उसको पैसा ट्रांसफर करते हुए जा रहे थे, एंड देयरफॉर वहां पे किसी भी तरीके की डाउरी रिलेटेड डिमांड की बात आप नहीं एज्यूम कर सकते हो। एंड ट्रायल कोर्ट ने इस आर्गुमेंट के ऊपर रिलाई किया that because there were multiple transfers of money which were being made by the accused family to Twisha, therefore there cannot be any demand for dowry. But the High Court rebutted or rejected this argument as well. The High Court rejected this premise. Examining the timeline, the court found that transfers occurred months prior to her death, and past financial transfers do not automatically neutralize subsequent dowry harassment or explain the immediate circumstances of her death. कि क्योंकि पैसे ट्रांसफर किए गए थे पहले, इस बेसिस पे आप ये नहीं कह सकते हो कि कोई डाउरी रिलेटेड हरासमेंट नहीं होगा। इट इज नॉट समथिंग व्हिच इज केपेबल ऑफ एक्सप्लेनिंग द इमीडिएट सर्कमस्टांसेस ऑफ अ डेथ, एंड दैट इज द प्राइमरी रीजन कि हाई कोर्ट ने यहाँ पर ये कहा कि ट्रायल कोर्ट ने सारे फैक्ट्स को कंसिडर नहीं किया प्रॉपर्ली, and thereby the court rejected the anticipatory bail or quashed the anticipatory bail which was given to Girabala Singh. अब एंटीसिपेटरी बेल है क्या, ये बेल होती क्या है, ये सारी चीजें वो अपन समझते हैं। दिस इज समथिंग इट इज इंपॉर्टेंट फॉर द पर्पसेस ऑफ आवर पेपर। सो नाउ हियर ऑनवर्ड्स we'll be discussing about what exactly bail is, what are the different types of offenses from the point of bail, and what are the different types of bail. बेल की अगर हम बात करें ना, तो बेल बेसिकली रेफर्स टू द रिलीज ऑफ एन अक्यूज्ड फ्रॉम द कस्टडी, रिलीज ऑफ एन accused from the custody, ठीक है, कस्टडी से इन्वेस्टिगेशन के टाइम पे पेंडिंग ट्रायल, दैट रिलीज ऑफ द अक्यूज्ड फ्रॉम द कस्टडी इज समथिंग इट इज नोन एज बेल। बट ये बेल का ऑप्शन एक अक्यूज्ड के पास आता कहां से? So when you look at Article 22 of the Constitution of India, Article 22 as a fundamental right gives certain kinds of protection to a person who is accused of an offense, ठीक है। सो व्हेनेवर अ पर्सन इज अक्यूज्ड ऑफ एन ऑफेंस, उसके अरेस्ट और डिटेंशन से रिलेटेड हम उसको कुछ वहां पर उसको रिलैक्सेशन देते। वन ऑफ द राइट व्हिच इज गिवन टू अ पर्सन इज दैट एवरी पर्सन हु इज अरेस्टेड एंड डिटेन्ड इन कस्टडी शैल बी प्रोड्यूस्ड बिफोर अ मजिस्ट्रेट within the period of 24 hours of such arrest, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. That whenever a person is arrested, that person is required to be produced before the nearest magistrate within 24 hours of the arrest, and he cannot be detained any further unless you obtain the custody from the magistrate or unless you obtain the authority from the magistrate. तो अगर मजिस्ट्रेट किसी पर्सन को फर्दर कस्टडी में रखने का ऑर्डर नहीं देते हैं, तो उस पर्सन को जो कस्टडी से रिलीज किया जाता है, दैट रिलीज इज डन थ्रू समथिंग व्हिच इज नोन एज बेल। तो अगर मजिस्ट्रेट ने कस्टडी ऑर्डर कर दी, डिटेन करके रखो इसको, ऐसा बोल दिया, तो पुलिस उसको फर्दर डिटेन करके रखेगी। बट अगर मजिस्ट्रेट उसको डिटेन करने की अथॉरिटी नहीं प्रोवाइड करते हैं ना, देन द पर्सन इज बाउंड टू बी रिलीज्ड ऑन समथिंग व्हिच इज नोन एज बेल। तो बेल एग्जैक्टली है क्या? बेल मीन्स रिलीज ऑफ अ पर्सन accused of or suspected of a commission of an offense from the custody of law upon certain conditions imposed by an officer or court on execution by the person or by such a person through a bond. एक प्राइमरली आपको श्योरिटी वहां पर देनी होती है, एक सिक्योरिटी आपको कोर्ट को प्रोवाइड करनी होती है। बट ये जो आपको लॉ में, ठीक है, कस्टडी से रिलीज किया जा रहा है along with certain imposition of the conditions, कोर्ट कुछ conditions आप पे impose करेगा, that you are not supposed to do this, you are not supposed to do that, But this temporary release of the person from the custody when the trial is pending or when the investigation is still going on, this temporary release from the custody is something which is known as bail. ठीक है? अब बेल के बेसिस पे हम ऑफेंसेस को दो कैटेगरी में क्लासिफाई करते हैं. There are bailable offenses and there are non-bailable offenses. ठीक है? From the point of view of bail, offenses are classified into two categories: bailable and non-bailable offenses. ठीक है? Bailable offenses are generally minor offenses. Non-bailable offenses are generally of serious nature. But the primary point of difference between bailable and non-bailable offense is that in cases of bailable offense, the person is having a right to be released on bail. Okay? If a person is accused of a bailable offense, then the person is having a right to be released on bail. अगर वो श्योरिटी प्रोवाइड कर रहा है, ठीक है, एज लॉन्ग एज द पर्सन इज प्रोवाइडिंग द श्योरिटी ओवर देयर ना, वो फाइनेंशियल गारंटी अगर वहां पर वो प्रोवाइड कर रहा है, देन द पर्सन इज हैविंग अ राइट टू बी रिलीज्ड ऑन बेल. आप उसको डिटेन करके रख ही नहीं सकते, उसको आपको बेल पे रिलीज करना ही होगा. दिस इज व्हाट अ बेलेबल ऑफेंस इज. बट देन व्हाट आर नॉन बेलेबल ऑफेंसेस? देखो, नॉन बेलेबल ऑफेंसेस का मतलब ये नहीं है कि बेल नहीं मिलेगी. ठीक है? It's not like that in cases of non-bailable offences, the person cannot be released on bail. The three persons who are accused of heinous offences or serious offences also, that they are actually released by the court on bail. But then what's the meaning of non-bailable offences? Non-bailable offences refers to those kind of offences wherein whether the person will be released on bail or not, that release on bail is dependent upon the discretion of the court. कि वो पर्सन रिलीज होगा या नहीं होगा, वो राइट नहीं है उसका. The person is not entitled to be released on bail as a matter of right. Whether the person is going to be released on bail or not, that depends upon the discretion of the court. Court की मर्जी है whether they want to release you on bail or not, and that is something which is known as non-bailable offences. तो bailable offense में the person is having a right to be released on bail. Non-bailable offense में it will depend upon the discretion of the court. ठीक है? So what are bailable offenses? So an offense which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force is known as non-bailable offense, and non-bailable offense means any other offense. So those kind of offenses which are declared as a bailable one in the first schedule of Bharatiya Nagarik Suraksha Sanhita, BNSS is the criminal procedural law of our country. So those offenses which are declared as a bailable one in the first schedule of BNSS or which are made bailable by any other law for the time being in force, those kind of offenses are known as bailable offenses. बाकी जितने भी offenses हैं, rest of the offenses will be considered as a non-bailable one. अगर जनरली हम इस चीज की डेफिनेशन देखने के लिए जाएं फ्रॉम द पॉइंट ऑफ व्यू ऑफ द अमाउंट ऑफ पनिशमेंट व्हिच इज बीइंग अवॉर्डेड इन सच केसेस, bailable offense basically refers to a kind of an offense, ठीक है, which would have which is punishable with imprisonment for less than 3 years or with fine only. Generally those kind of offenses are considered as a bailable one in our country, wherein the amount of punishment which is awarded in respect of those offenses is around 3 years or less than 3 years or with fine only. So example can be offenses like simple hurt, defamation, stalking. These are the kind of offenses which are considered as bailable one. Okay? And this right of the person to be released on bail is not something which is only given in theoretical books. That is something which has been declared by the Supreme Court of India in the case of Rasik Lal versus Kishore in the year 2009. The Supreme Court made it clear that in case a person is arrested for any bailable offense, his right to claim bail is absolute and indefeasible, and if the person accused is prepared, the court or the police, as the case may be, will be bound to release him on bail. So herein it is not dependent upon the discretion of the court or the officer that whether they want to release you on bail or not. If you are accused of a bailable offense and if you are arrested because of a bailable offense, it is an absolute right of the person to be released on bail. It is not dependent upon the discretion of the court. That is the thing about bailable offenses. But when we look at non-bailable offenses, these are the kind of offenses which are more serious in nature. And typically offenses punishable with more than 7 years of imprisonment up to life imprisonment or death penalty are kept under the category of non-bailable offenses. So generally the amount of punishment which is being given in cases of non-bailable offenses is these are the kind of these are the kind of offenses which are punishable with more than 7 years of imprisonment or with life imprisonment or death penalty. And they are considered as serious offenses and therefore they are kept under the category of being a non-bailable offense. So in cases of non-bailable offenses, the gravity of offense is a bit higher and sentences are higher in the case of non-bailable offense as they are punishable with imprisonment for life or imprisonment which may exceed 3 or 7 years. And in non-bailable offenses, this is very important. Bail is not a matter of right, but rather it is a matter of discretion of the court of law. That whether you are going to be released on bail or not, that is not a matter of right. You cannot claim it as a right of yours that you are bound to be released on bail. It will entirely depend upon the discretion of the court. The court will decide that whether they want to give you a bail or not. So the types of bail which are claimed in cases of non-bailable offenses, okay, the different types of bails which are claimed in the cases of non-bailable offenses includes regular bail, interim bail, default bail, and anticipatory bail. Regular bail, interim bail, default bail, or anticipatory bail. So the first one is your regular bail. So any bail which is filed in cases of non-bailable offenses is considered as a regular bail. Okay. Now whether you are going to be released on bail or not, that will depend upon the discretion of the court. So let's say if a person is accused of committing dowry death and they are arrested by the investigation agency, subsequently they will file a bail in the court of law. This kind of a bail will be considered as a regular bail. Okay. So when an accused is presented, he or she may be released on bail at the discretion of the court, except in the following cases. There are certain cases wherein the court will refuse to exercise their own discretion and the court will refuse to give you the bail as well in matters of non-bailable offenses. Okay. Now, whether you are going to be released or not, that entirely depends upon the discretion of the court. But in certain cases, the court will not even exercise their discretion and they will deny to give you a bail as well. कौन सी conditions हो सकती है वो? So when there exist reasonable grounds for believing that he has been guilty of an offense where the quantum of sentence is imprisonment for life or death. So if the court thinks that you have actually committed that offense or you have actually committed a kind of an offense which is punishable with life imprisonment or death penalty, that is one such situation wherein the court will deny to give you bail. Similarly, when such an offense is cognizable in nature and where he has been previously convicted of an offense which was punishable with death, imprisonment for life, or imprisonment for 7 years or more, in that situation also the person will not be released on bail. So if the court thinks that you are accused of committing a cognizable offense, what kind of offenses are considered as cognizable offense? Those offenses wherein the police can arrest without warrant are considered as cognizable offenses. These are also serious offenses. ठीक है? तो अगर आपने कोई cognizable offense commit किया and it has been shown to the court that you have been convicted of an offense previously as well, and that offense was punishable with minimum 7 years of imprisonment up to life imprisonment or death penalty, then the court will deny to give you any bail. Similarly, he will also not get bail if he has been convicted on 2 or more occasions of a cognizable and non-bailable offense. अगर पहले भी आप 2 या 2 से ज्यादा बार किसी cognizable and non-bailable offense के लिए convict हो चुके हो, then also the court will deny to give you bail. ठीक है? एंड जनरली जब कोर्ट रेगुलर बेल अवार्ड करता है ना या किसी भी तरीके की बेल अवार्ड करता है किसी पर्सन को इन मैटर्स ऑफ योर नॉन बेलेबल ऑफेंसेस, द कोर्ट आल्सो अटैचेस सर्टेन कंडीशंस ओवर देयर. कुछ कंडीशंस वहां पर कोर्ट अटैच कर देता है. जैसे द कोर्ट कैन इम्पोज कंडीशन दैट अक्यूज्ड पर्सन शैल अटेंड द कोर्ट प्रोसीडिंग्स इन अकॉर्डेंस एंड कंप्लायंस विद द कंडीशंस स्पेसिफाइड ऑन द बॉन्ड. Okay, that you will be present in the court whenever called upon. Similarly, accused person while he is on bail shall not commit an offence same as the offence of which he is accused or suspected. This can also be attached as a condition. A similar kind of offence nahi commit karna. Then the accused shall not directly or indirectly induce, make promise or threat to any person who is familiar with the case so as to prevent him from disclosing incriminating facts to the police officers or tampering with the evidences. This kind of a condition can also be attached by the court that when you are out on bail, you will not try to communicate or contact with the witnesses or the victim family, and so on and so forth. And therefore, what Giribala Singh did through the press conference, that can be considered as one of the major, uh, the reason that why the High Court got inclined towards quashing that bail as well. Because the court had given you an anticipatory bail, that is, you are given protection from a future arrest. And in that situation, conducting a press conference wherein you are maligning the image of the victim, who is not even present anymore to defend herself, that is something which is questionable, especially when the investigation agencies are claiming that she was not even cooperating with the investigation agencies in the investigation of the matter. Okay, but these are the kind of conditions which can be imposed on a person who is being released on bail in a case of non-bailable offence. Okay, another kind of bail is known as interim bail. Now, interim bail basically refers to a bail which is given for a particular interval, that is for a specific time period. So, if the court releases a person from custody for a limited period of time, like recently, the Delhi High Court gave an interim bail to the person who is accused of committing an offence under the UAPA, wherein the court awarded him bail for a period of 3 days. This is what an interim bail is. Interim bail is given for a specific period, for a specific interval. So the bail is granted for a specified period of time by the court, and the interval can be for 15 days or even a month or any number of days. Okay? The point is, after the expiry of the granted period, okay, after the expiry of the granted period, the accused is again committed to the prison. So once that time period is over, you are supposed to go back into the custody when the person is being released for this kind of a time period. This is considered as an interim bail. And interim bail can only be granted in case of a non-bailable offence, since in bailable offences, bail is a matter of right. Because bail is a matter of right in cases of bailable offences. So interim bail is something which is granted in cases of your non-bailable offences only. Okay. The next type of bail is default bail. Now, what is the default bail? Default bail is given to a person for incompletion or for non-completion of investigation agency within the stipulated time period. Okay. देखो general rule is investigation agency is supposed to complete their investigation within a specific period of time, and that report which is prepared by the investigation agency, that report is known as charge sheet. That report is known as charge sheet. So investigation agency is required to submit this charge sheet within a specific period of time to the court. If the charge sheet is not being presented to the court within that period of time, then the accused become entitled to be released on bail. And when a person is being released on bail because of non-submission of the charge sheet within that time period, that kind of a bail is known as default bail. Okay? So if the investigation officer does not file the charge sheet within a specific prescribed time period, which is 90 days for an offence punishable by death, imprisonment of life, or imprisonment for a term of not less than 10 years, and 60 days in the case of any other offence except the former ones. So generally, wherever the offence is punishable by death, life imprisonment, or a minimum imprisonment of 10 years, There, the investigation agency or officer is having a time period of 90 days to submit the charge sheet. And in rest of the cases, the time period is 60 days. So if the charge sheet is not being submitted within this time duration, then the accused becomes entitled to be released on bail. And if the accused is being released on bail because of non-submission of the charge sheet within the time period, that kind of a bail is known as default bail. Okay? So we had regular bail, we had interim bail, and we had default bail. The point is how these three bails are different from anticipatory bail. Regular bail, default bail, and interim bail will be given to a person wherein the person is in already custody of the police. Okay? The person is already detained. The person has been already arrested by the police. And after the detention or the arrest, you are filing a bail over there. Anticipatory bail is different from these kind of bails in that subject matter, that herein the person is not arrested yet. Okay? Herein the person is not arrested yet. The person is trying to claim protection from a future arrest. In the anticipation of the arrest, the person wants to seek a bail. That is something it is known as anticipatory bail, beta. Okay? So anticipatory bail is a kind of a protection against future arrest, wherein a court grants bail to a person who has reasonable grounds for arrest in relation to a non-bailable offense. That the person is expecting that the police might arrest him. Okay, the person is expecting that the police might arrest him. So in anticipation of that arrest, in order to be protected from getting arrested by the police, the kind of a bail which is given to a person, the protection which is given to a person is known as anticipatory bail. Anticipatory bail is generally filed or applied in high courts and session courts. Okay? And the court, before granting anticipatory bail, considers the following thing, like the nature and gravity of accusation, past criminal record, possibility of the applicant fleeing justice, that is, the person might abscond as well. These are the kind of things which the court will consider before granting anticipatory bail to a person. So, in our present case, Giribala Singh was actually awarded anticipatory bail by the court only. She was having an apprehension that she might get arrested by the police, and in anticipation of that, she took the protection, or she got the protection from the additional sessions court. But now the High Court had quashed this particular bail, which was given to Giribala Singh. Now, the topics which are important for the purposes of our paper is understand the difference between bailable and non-bailable offences, and what are the different types of bails which are involved over there. Okay? So, I hope the topic is clear. I hope the things are clear. Okay? Baki, just take care of yourself. Just enjoy your day. Keep studying. And I'll see you soon, guys. All right? Thank you so much, everyone. Thank you so much, guys. Thank you so much. Thank you.